Welcome to the second roundtable discussion today. This one is dedicated to the Human Rights Center established within the Central European Association for Comparative Law in 2024. I feel very privileged to welcome you as the moderator of this roundtable discussion and also in my capacity as the chairwoman of the Human Rights Center. Firstly, I would like to introduce our distinguished guests and panelists, all of whom are honorary members of the Human Rights Center of the Central European Association of Comparative Law. To my right, Professor Peter Kovacs from Pázmány Péter Catholic University in Budapest and the former judge of the International Criminal Court. Professor Peter Pacolai, Professor Emeritus of the University of Szeged and judge of the European Court of Human Rights. Professor Aleksandra Syryt from the Cardinal Stefan Wyszyński University in Warsaw, Poland. Professor Katarina Śmigłowa, Dean of the Faculty of Law of the Pan-European University in Bratislava, Slovakia. And Professor Paweł Sobczyk from the University of Opole, Poland. Dear honorary members, we are very honored that you are here and that you have accepted our invitation. Dear colleagues, dear ladies and gentlemen, we have organized our today's roundtable discussion to promote the Human Rights Center, which intends to be a platform for scientific cooperation, scientific dialogue among scholars and practitioners interested in the international human rights law, both at the university level and at the regional levels as well. We hope that the Human Rights Center can become a genuine hub for cooperation and research, which reflects the cultural and legal heritage of the Central and Eastern Europe. The topics of our today's roundtable discussion are inspired by the topics which are most frequently addressed on the Central European Researchers blog. I think you can see on the screen several posts on the left side of the screen. The Central European Association of Comparative Law operates a blog, and we have identified that there are several recurring legal problems on the blog. They are connected to the relationship between international law, EU law, and the domestic legal orders. They are connected to the jurisprudence of the European Court of Human Rights, the case law of the Court of Justice of the EU, as well as children's rights, rule of law, economic governance, or global security issues. I warmly invite you to visit the webpage of the Central European Association of Comparative Law of the Human Rights Center and to check the blog, of course. Now let me turn to the first set of questions. To begin, I would like to ask our dear panelists how their national legal systems defines and conceptualizes the relationship between international law and the Constitution. So, starting from Poland, from the farthest corner, dear Professor Sobczyk, I would be very interested in how Polish legal system formally defines the relationship between international law and the Polish Constitution.
Ladies and gentlemen, first of all, good afternoon. Thank you very much for the invitation. I'm happy that I can be here with you. And about your question, if we read Polish Constitution of 2nd of April 1997, everything is clear. Article 8 of our Constitution, the Constitution shall be the supreme law of the Republic of Poland. And Article 9, the Republic of Poland shall respect international law binding upon it. So, if we read these two articles of our Constitution, everything is clear. If we read the case law of Constitutional Tribunal, for example, the judgment of 11 of May 2005 concerning the accession treaty and the relationship between Polish constitution and EU law, everything is clear. Constitution is supreme law of the Republic of Poland. If we read all commentary to the Constitution from end of 20th century of beginning of 21st century, everything is clear. Constitution is supreme law of Republic of Poland, but we respect the Constitution, respect international law. But if we read new commentary, if we hear new politician, or if we hear debate about EU law in Poland, international law, now we have new situation, because a lot of people think that the EU law or judgment of Tribunal from Luxembourg or Tribunal from Strasbourg is the supreme law than Constitution. This is a very special situation because the judgment is not source of law in Poland. But this is the thing, the interpretation of our Constitution, interpretation of treaty is the supreme law of Poland sometimes. For example, we have Article 18 in our Constitution that the marriage is the woman and man. And 3 weeks ago, our Supreme Administrative Court, here the Tribunal from Luxembourg, that we have right in Polish law that the married is woman, man, and we have to do transcription for our law. But we don't change the Constitution. 20 years ago, the Polish Constitutional Tribunal said, no, it's not possible. We must change the Constitution if we can do this. So this is the evolution of relation between our constitutional law, our Constitution, and EU law. Evolution or revolution? Yes, it depends because it's 20 years, so maybe it's revolution. Yeah, thank you.
I've heard that Polish legal experts are working on a new constitution, so I hope it won't be so revolutionary. Let us stay a little bit longer in Poland for a while, and I would like to ask Professor Aleksandra Syryt more specifically about the European Convention on Human Rights. What is the place of the European Convention within the Polish legal order?
Thank you very much. As Paweł mentioned, Constitution is supreme act, and we have another provisions in Constitution. We have a special chapter on the sources of law. In this chapter, international agreement which were ratified are universally binding law. And Polish European Convention on Human Rights was ratified before enacting Constitution of 1997, but in intertemporary provision, it was said that ratified convention, ratified agreement, international agreement, which concern human rights, are a part of the system, and they are above the statute, but it is not the relation between statute, international agreement and constitution, only when there is a collision in application of the statute and this Convention on Human Rights, the convention has first place. But we have another provisions about the competencies of Constitutional Tribunal, and in this competences it is written that Constitutional Tribunal can judge and can verify the accordance, compliance the international agreements with the Constitution. So it means that European Convention on Human Rights could be verified if it is in accordance with Constitution, and 2 times Constitutional Tribunal of Poland did it. It was a kind of response on European Court on Human Rights verdicts on courts and tribunals cases mentioned today earlier. And the Constitutional Tribunal judged that Article 6 of the Convention in particular meaning is unconstitutional. So here is the position. But for all years when the Constitution of 1997 is in force, and even before, as I said earlier, the Convention and the jurisprudence of European Court on Human Rights, they were inspiration for interpretation provision on constitutional rights and freedoms, and they have built a standard of shaping legal provisions. Today we have also the standard is followed, but sometimes, as Paweł mentioned, it is abused, and Convention and European Court on human rights verdicts are used as explanation of behaviors of government which does not have the legal basis in Polish legal system. So, thank you.
Thank you very much for these insights from Poland. Now I would like to move to Slovakia, and I would like to ask Professor Śmigłowa about the relation of the international law and the Slovakian constitution and domestic legal order.
Thank you. Let me join you to thanking for the invitation and to share the experience from the Slovak Republic. As for the relationship between international law and Slovak national legal framework, leaving aside EU membership and EU secondary rules, it is regulated directly by the Constitution itself. There are several parts of the Constitution dealing with this relationship. The first of them is Article 1, saying that Slovakia respects its international commitments, international legal commitments, also general international legal commitments. It means international customs. And then there is a more specific article dealing with international treaties, talking about the validity of international treaties, what are the conditions for the validity, for the process of ratification, promulgation, and so on. What is very important, there's one part of this Article 7 talking about priority over national law, not over the Constitution, as it has been already explained here, the difference, but over national laws. And there's a list of international treaties that have this priority. So not all of international treaties, they have this priority, but as for human rights, because this is about Human Rights Center and comparison, so as for human rights international treaties, they do have priority. And in that case, if interpreted by national courts, they are bound by these international treaties. Nevertheless, I presume that you must have heard, or you might have heard, about the great big amendment of our Constitution that was adopted last September 2025. And that amendment included the issue of national identity. And that was something that really brought many discussions, not only within academic area. It's been politicized very much. To make it short, because this is only the first question and there are other people being asked to talk about their systems, just to make it short, we've got a notion of national identity directly within our constitution. And there are two paragraphs of Article 7 talking about this national identity. First, that Slovakia has not transferred execution of its rights concerning dealing with the issues, matters of national identity. That's paragraph 7, and then talking about what actually national identity is. And that is a complicated issue, and this will be a very important issue also to do if you're interested in your PhD studies or other research, because this is a big challenge concerning national identity and the issue of cooperation, not only in relation to international treaties, but also EU commitments. So just to generally answer your question for the first round.
Okay. Thank you very much. And finally, we have arrived to Hungary. And I would like to ask Professor Peter Patolai, if I can start with Justice Patolai, and ask for a short explanation about the relation of international law and international human rights law and the Hungarian constitution.
I'm sorry that he's sitting my friend, outstanding international lawyer in Hungary, so I'm just a simple human rights lawyer, so I think that he's more appropriate to answer this general question.
Thank you very much. Well, it was interesting for me to listen to you that in written form everything is so clear in the Constitution. Congratulations. in Hungary this is not so easy, not so simple. And you know, in my textbook about public international law, I guess that 35 pages about are devoted to the constitutional jurisprudence. And in fact, even the text of the Constitution is not so clear for our foreign friends. I would like to say that even the structure of the Hungarian Constitution or fundamental law is a bit bizarre, because there are articles numbered with letters A, B, C, D, etc. And after that there are articles numbered with Roman numbers. And after that, there are also articles numbered with Arabic numbers. And so since the beginning, there is a dispute in Hungary or in the constitutional sphere, at the Constitutional Court also, whether there is a hierarchy between articles numbered with letters or numbered with Roman numbers or with Arabic numbers. So this is the first problem with that. Secondly, in general terms, the same rules are written in the Hungarian constitution. It was mentioned by Professor Smigova that the Pacta sunt servanda is mentioned there, and it is also mentioned that the treaties shall be executed in the Hungarian legal system with promulgation. And so the general rules of international law shall be executed. Other sources of international law should be promulgated prior to the execution. And in fact, it means that treaties are generally promulgated, except those where, for different reasons, whether by negligence or other factors, the parliament or the government was unable to execute the promulgation. And so, on international level, the given treaty was already binding because Hungary duly ratified that. This was the case of the Rome Statute of the International Criminal Court, or a convention contracted with the Holy See, which were not promulgated in the Hungarian law. Nevertheless, some of the most important parts were executed. So, in fact, this is one of the problems. The other is that very often politicians consider that the aim of the constitutional protection is to protect the constitution as such. Others say that, in fact, the real aim is to protect the fundamental rights. And so that's why the real question is, of course, not the collision of international commercial treaty with the constitution, but the collision of the commitments assumed via the international conventions, like European Convention on Human Rights, and the given national legal rules concerning that or that right, whether in social sphere, whether in criminal law or civil law, and so on. And when I arrived to the Constitutional Court in 2005, at that time the main rule was that we are so good in the constitutional protection of human rights that whatever let's say, direct approach to the European Convention on Human Rights and the jurisprudence of the European Court of Human Rights is quasi-useless because the constitutional protection is certainly better and stronger. And in fact, what we realized also that at that time there were references and citations from the jurisprudence of the Strasbourg Court, however, with very old cases. Let's say from the 60s or 70s, 80s, and so on. And so what we succeeded to do with my friend Judge Pacolai was to direct the jurisprudential approach of the Constitutional Court the way that the jurisprudence of the Constitutional Court should attain at least the same level of the protection of fundamental rights, what is promoted, what is secured by the international treaties, namely the European Court of Human Rights. Of course, it is easy to say that or to pronounce that by a constitutional decision. To implement that rule was much more complicated, because the real issue is how to check what is the Strasbourg jurisprudential line, and so how to make a distinction whether there is an already strong, clear jurisprudence, and when there is only a single decision which are not really clear, especially if it is on the if it was taken by a 7-member chamber and not by the Grand Chamber. So we have to check that. And I think this is one of the most important let's say, job of the constitutional judges to do that, and also to check the real compatibility or uniformity of the rules of the Constitution or fundamental law and the given rules of the European Convention of Human Rights. There are a verbatim unicity concerning some rights, but there are other rights where the formulation of the Hungarian Constitution is not totally the same, very similar, but not totally the same as in the European Convention of Human Rights or the International Covenant on Civil and Political Rights. And so if there is a certain difference between the constitutional wording and the international wording, this, let's say, openness to the European or international jurisprudence, this is not so evident, and there kind of a judicial caution should be emphasized. And we arrived to that, and at least this rule has been since then rather often repeated by our fellow judges at the Constitutional Court, that the main policy is to grant at least the same level of protection. If the Hungarian constitutional protection is better, okay, it's very good. If this is lower at that time, in fact, the Constitutional Court should pay attention to grasp the level of international protection, and when the Constitutional Court should refrain from considering a Hungarian legal norm as compatible with the European Convention of Human Rights if the jurisprudence of the European Court of Human Rights says contradictory. This is in fact very important also for the Constitutional Court in order to preserve the integrity and let's say intellectual respect among the constitutional courts as such.
Thank you very much, dear Professor, also for sharing with us these experiences from your experience at the Constitutional Court. Now I'm turning to Professor Pacolai. Would you like to add anything from your own perspective?
Thank you. I think now it's clear why I was insisting that he took the floor, because with these ideas he had a great impact on the Constitutional Court's jurisprudence. Myself, as I was from the very first day working at the Constitutional Court, was under the influence of this oldest doctrine that we have always to surpass and be higher than the Strasbourg Court and so on. And we arrived more or less the same time. I arrived in February 2006, so we spent our term basically together. And we had several discussions, but I was convinced of this doctrine, yes, because Peter is modest, but I can call it the Kovács doctrine of the relation. And I think this in long run, so now looking back after 36 years, this for long run gave a much more protection to the Constitutional Court's jurisprudence as making efforts always to be smarter than the Strasbourg Court as political changes came and so on. The second personal remark, when asked him about international law question, and after giving the answer, he remarked that, by the way, I wrote 30 pages on it in the textbook that I gave to you as well. And that was the case. And my third remarks was that really in the text of the Constitution, inherited partly from the Socialist Constitution, but these paragraphs on the international, of course, were rewritten, and was not, the text was not really clear at the beginning, and also now is different. And of course, the similar cases might arise also with Hungary, because we had always in the constitution that the marriage is between a man and a woman. And strangely enough, this was written by the communists into the constitution, because there, at least the explanation given by the commentary, there were fears that the Soviets will introduce a system that abolishes the family, and young people will living in Makarenko-style institutions and so on, and to calm down the public opinion, they wrote into the constitution this rather simple sentence, which after decades or nearly after 8 years or so on, now has a different meaning in the international context.
Thank you for this first round of very inspiring answers. And now I would like to turn to some more specific, more concrete examples, maybe experiences again. And I would like to ask for a short answer. Is there anything more specific than just the general interaction between the international law and the constitution from your countries that you would like to emphasize? Are there any specific legal problems, for example, in your countries that touch upon these questions? How about Slovakia, dear Professor Šmigova?
Thank you. So this time I'll start at first and I'll try to be as short as possible. 3 points have just come to my mind. First, maybe the clause was similar if what has been said here about the priority and about greater protection, if compared to, for example, the European Convention and the constitutionally recognized fundamental rights. But this has been changed. There was a big amendment, not the one from the last year, and now that part is an intertemporal clause. So it still concerns the convention, but it does not concern other international treaties adopted later after the relevant amendment. So now the position about the greater protection is not as if applicable anymore to the newly ratified and promulgated international treaties. So that's from the comparison perspective. Second point concerns the certainty that was mentioned here and confirmed there. As for the amendment from the last year that I mentioned about the national identity, I think that the 6th paragraph of the 7th article actually does not add anything to certainty at all, quite on the contrary. Because as for the definition of the national identity, there are parts that you don't want to see within a definition in a constitution, because that paragraph includes notions like above all. So it is not a good tool for the Constitutional Court. And it has been said and discussed that it would depend on the composition of the court what the interpretation would be. And that's very strange because as for a decision is not a general source of law in Slovakia either. But this provides great opportunity for so-called judicial lawmaking through interpretation. So I'm trying to make it short. What I have found much more interesting last month, it is a decision of our Constitutional Court that dealt with the status of decisions of so-called quasi-judicial bodies. I mean, committees that function under UN committees. And I'm mentioning it here because within the cooperation and the Central European Academy, myself, I wrote an article about how these decisions are not legally binding. And there's a new decision of our Constitutional Court based on Pacta sunt servanda, pointing out about the execution of the decisions of these committees. Through Pacta sunt servanda application, they have decided and regulated that these are decisions that are to be executed. And Slovakia, from the internal perspective, actually not from the perspective of an international body, has been asked to make sure that these decisions are executed. So that was actually a fundamental change within the decisions, the case law of our Constitutional Court. So these 3 specific points that I wanted to mention here.
Okay. Thank you very much. And how about Poland, Professor Sobczyk? What is your perspective?
From my perspective, I would like to address maybe 2 examples from human rights. First is the redefinition of rights and freedoms. In 1993, Poland started to be a member of the Council of Europe, and our constitution is, as I mentioned, 1997. So the second chapter of our constitution is about freedoms and rights. And a lot of articles of our constitution are a copy of European Human Convention of Rights. Yeah? And now the problem of interpretation. We know that the Human Convention, European Convention, is living instrument. A constitution is quite living instrument. But the question is, the problem is, what if a national court or tribunal interprets a freedom or right differently than international court or tribunal? Example, from 13th of November 2025, it was the case in Strasbourg, AR versus Poland. It was about right to privacy and so-called right to abortion. And the tribunal in Strasbourg opened a door, small hole only, for the interpretation that so-called right to abortion is a part of right to privacy. But Polish Constitutional Tribunal don't do this. The Polish Supreme Court don't do this. And now it's problem. Where is the interpretation of law, of the freedom of rights? Where is the redefinition of rights? We know this because His Excellency told us today morning that convention has 70 years. It's old convention. Our constitution, 29. It's living instrument. So we interpret these two acts. But where is the border between interpretation of freedom of rights and where is the redefinition of this freedom of rights? I think this question is open. It's not easy as an interpretation of Article 8 or 9 our Constitution. And second problem, if I may, is effectiveness of human rights. What is the effectiveness in the level of European Court of Human Rights? What is the effectiveness in other countries? Because from the perspective of citizen, we know that we have a high level of normativization of human rights. We have a high level of internationalization of this. But the problem is when the person goes to the judge and must wait 5-7 years. After a judgment, this is the problem in Poland now, the other side told this person, no, we must go to the second level of judgment because in this court was the new judge. Yeah, this is the problem of Polish judgment now. And it's the same situation, I think, in Strasbourg, when the person go there, must wait a long time for the decision. Thank you.
Thank you very much. Dear Professor Syryt, would you like to add something from the Polish perspective?
Yes. First thing is, as we mentioned, that Constitution is from 1997, so in the Constitution there are no provisions about participation in EU and relation between, for example, these acts as fundamental European Charter of Fundamental Rights, because it is newer. And we treat in Poland, on the basis of the Constitution, EU law as international law. And today it is quite something different. And the interpretation and also education of these two legal systems in the sphere of fundamental rights is different. Second thing are the perspective. From the national perspective, we have to follow Constitution. and its fulfillment. And from the international perspective, there is pacta sunt servanda. And what should happen when, for example, Constitutional Tribunal said that convention, some provision of the convention are not in accordance with constitution. Internal, this provision should not bind us because Polish verdicts on constitutional courts are universal binding. But from the perspective of international law, we are not fulfill our obligation to pacta sunt servanda, and in international law we can't say that in our domestic law there are provisions different, and we can't explain our behavior by domestic law, and it is unsolved problem. And very in such important things as the interpretation, but the kind of creation of norm on the by European Court on Human Rights, different than the meaning of the norm of the Constitution on fundamental rights, it's difficult to resolve how to cope with it. And these two examples done by Professor Paweł Sobczyk are excellent example what to do. And another thing, we should remember that, of course, there is European Court on Human Rights, and this court built a standard of protection in the region, but it is up to the state how to fulfill, how to execute fulfill this requirement from the judgment. So there is a compensation, and it is the most easier one. But what to do if, for example, as with abortion, we have our Constitutional Court verdict about protection of life, and there is a European Court's verdict about so-called right to adoption, how to cope with it. Could the state violate its constitution? And here is the problem to cope with it, and I will leave you with it.
Okay. Thank you very much. And I'm very much curious about the Hungarian issues in connection with the specific, let's say, interaction of the international law and constitutional law. Dear Professor Pacalai, can I ask you for an opinion?
Just one remark that it is possible conflicts between international courts and the constitutional system and the constitutional court of the countries. Just like to remind you that there is a huge difference between the approach of the European Court of Justice of the European Union, because what is now is a clear philosophy to uniformize and unify the European law, which is, in my humble view, is also against the principles of federalism, because even in the United States, a lot of legal fields are not uniform. What is now a more and more clear purpose of the European Court of Justice. On the other hand, the European Court of Human Rights is sometimes severely criticized because, and this is unique in the practice of international courts, applies this margin of appreciation doctrine that leaves to the national courts, first of all, to take the first decisions, but even more in questions when there is no European consensus, and these are these morally scheduled issues, for example, of the gender change, the abortion, same gender families, and so on, and we leave the decision to the national authorities and national states, and this is a huge difference. And even if it might be criticized that our court does not give clear and straight answers to these issues, but this is also for historical reasons, I always underline, to leave a certain margin of discretion to the countries.
Thank you. A couple of times I have heard the magical expression "pacta sunt servanda," and I also saw the meaningful glance of Professor Śmigłowa when she was looking here in this direction, and I thought that I will ask Professor Kovács about his opinion, for example, on the fulfillment of international obligation, especially in the context of sovereignty.
Well, before that, before answering that, I would like to be more abstract, in the sense that I guess that one of the reasons of the current conflicts between the international courts, tribunals, and let's say national governments or parliaments are due to the fact that what was effectively said in the given judgment. And the judgment of the European Court of Human Rights is long and very heavy text. The judgments of the International Criminal Court are even longer. Let's say, to have a 1,000-page long judgment, this is not exceptional at all. So very often these are the different political groupings or legal councils or NGOs and others or journalists, with all my respect to them, who are trying to reinterpret what has been said by the given international court. And so they either by negligence or deliberately, they are trying to mention these tricky formulation that within the strict specificities of the given case. And so very often, in fact, in the doctrine or in the political life, a different outlook is reflected concerning the given judgment. And so that's why when the NGOs are pushing to go harder or further and further in the direction of the evolutive jurisprudence, there are some shocks when the given court does not do that. And the judicial caution is a very important behavior or behavioral rule or policy of the international tribunals, and it was very nicely explained in the famous case, probably you have heard about that, Karsai versus Hungary. It was an euthanasia case before the European Court of Human Rights, and I was talking that with Agent Talodi today. In fact, it was so nicely or logically explained by the court how to make the distinction where there are kind of a common position, common perception of the given human rights, where there is a certain consensus, and there are also other topics, other rights, where for the time being there is no consensus, and so there, as Judge Pazzoli mentioned in his keynote speech, the states are much freer than considering other ones. And so that's why, in fact, these conflicts between parliaments and governments on the one hand, international tribunals on the other, are due to the fact that this was so difficult to read all these 100 and 1,000 long page long decisions. Answering, however, your precise question concerning the national sovereignty and the protection of human rights, what is, I think, very important is that the meaning of the sovereignty currently is different as this notion was conceived in the 19th century. And so at that time, states, I mean in 19th or 18th century, states were not ready to accept tough international commitments. Currently, they are generally ready to do that because they they consider that it's worth to do that because of economical values, because of other corporations, because of, let's say, health issues. Just think on the COVID and, let's say, WHO vaccination program. I guess that it was very good that the whole world was, nearly the whole world has been vaccinated, and in fact we survived this epidemic as such. And where I have the similar opinion, if I understood well, Professor Katarina Šmigova, is that the notion of national identity is a bit, let's say, very tricky or very dangerous, because in those countries where it was conceived historically, whether this is the Federal Republic of Germany, national identity means practically the observation of fundamental rights as such. The same is in Spain, and in fact in Spain even the kingdom does not belong to the national identities as such. And so what is where I am a bit afraid is when there are some, let's say, some movements who are trying to interpret the national identity concept to all the small issues, which are sometimes really technical ones. And so what I would like to emphasize is that I am afraid that here in Central and Eastern Europe, the territory of the so-called national identity is much larger than in Germany or in Italy, where this doctrine has been conceived. And sometimes there are also a certain, let's say, fear that it's a bit the return of the monism of Soviet type, where this is the national law, which should be over the international commitments. And so I think that it would be very dangerous to go back to this absolutist perception of the sovereignty.
Okay, thank you. And with this thought, I would like to close our today's roundtable discussion. I hope that we can continue this inspiring debate during the dinner and afterwards. And thank you very much for all your contributions here. And now let me wish you a pleasant afternoon.